Hotel Liability for Guest Property from Common Law Through Today by Melanie Blasky.
Hi, welcome to Caesars.
Hi.
Hello.
Checking in?
Yes.
Yeah, we have a reservation under Dr. Price.
Okay, let me look that up for you.
Doctor.
The term innkeeper is an old-fashioned term used to refer to the person who ran an inn. It is used in the present to refer to hotels and motels. Origin of innkeeper's responsibility for property of guests. In the earlier time, the most important function of an innkeeper's was the furnishing of food and drinks. After that was protecting the traveler against nocturnal robbers. If a traveler was robbed at an inn, it was from defect care of the innkeeper. As early as 1367, it was decided that the innkeeper is responsible of the goods of the guests stolen from the inn. The loss was alleged to be for defective regard of the innkeeper and his servants. Under English common law, an innkeeper was deemed responsible for the full value of any property of a guest or a visitor. Wise v. Hoffman House, June 1899. This is an action by a guest against an innkeeper to recover damage for loss of property. On December 8, 1898, the plaintiff and his wife registered at the defendant's hotel and were duly assigned to a room. Their baggage consisted of a steamer trunk and traveling bag containing toilet articles. During their absence from the hotel on the following evening, the traveler bag and contents together and with some wearing apparel was stolen. Prior to their departure, the plaintiff had locked the room and handed the key to the night clerk. There was no proof of fraud or negligence on the part of either. The plaintiff claimed that the value of the lost property was $310.25, in which sum he paid judgment. On this proof, he was awarded $275 and the defendant appealed. The common law rule defining the liability of an innkeeper to his guests for the loss of property given in his custody as that of an insurer has been steadily and firmly upheld by our courts in the latest cases, even as the earlier ones make him absolutely liable without any proof of negligence on his part for all losses occasioned from any cause other than the act of God or the public enemy. In 1909, the Washington State Supreme Court approved 3 exceptions to an innkeeper's common law liability of an insurer. The court ruled that an innkeeper is the insurer of the property of his guests and liable for its loss from any cause, unless such loss comes from an act of God or the public enemy or from the neglect of the guest himself. Under common law, an innkeeper was liable for loss or damage to a guest property for the full value, unless the loss was caused by an act of nature.
Here's another look at the force of the wind as it tore the roof off that inn in Yarmouth. In this video, you can actually see it come off and then go flying beyond the property.
Civil unrest or fault of the guest. Today, this general rule still exists, but states have modified the common law by enacting statutes that limit the hotel's liability, provided the hotel complies with the statutory requirements. Although amounts vary from state to state, liability ordinarily is limited to a specific figure, which typically ranges anywhere from $250 to $2,000. Hotels typically post notices indicating that valuables worth more than a certain amount must be deposited in the hotel safe in order to be covered for any loss. Room safes are generally recommended only if they contain digital keypads and the guest assumes all responsibility for getting into the safe and keeping the combination confidential. Although a hotel's liability is limited by statute, the limitation applies only if the hotel has followed the requirements of the statute concerning the posting of notice of the availability of states. In the situation where those requirements are not followed, the limitation would not apply and the hotel could be responsible for the full value of stolen or damaged property. It's very important that the hotel management is familiar with the law applying in their state as well as any updates to the law. The state of Arizona has the lowest liability with $100. The state of South Carolina has the highest liability with $2,000. I live in the state of Pennsylvania, so I wanted to research these laws as they personally affect me. 2021, Pennsylvania Consolidated and Unconsolidated Statutes. Title 48, Lodging and Housing. Chapter 13, Hotels. Section 1323, Liability for Property Loss or Damage. General Rule, except as provided in subsection B and section 1325, relating to special arrangements for safe deposit of valuables. No hotel keeper or campground owner, whether individual, partnership, or corporation, shall be liable for loss or damage to property suffered by a guest, unless the hotel keeper or campground owner fails to constantly maintain any of the following. A metal safe or vault in good order and fit custody of money, banknotes, jewelry, gold or silver articles, precious stones, personal ornaments, railroad mileage books or tickets, negotiable or valuable papers and bullion. This paragraph shall not apply to campground owners. Suitable locks, bolts, and fastenings on the doors, transoms and windows of the sleeping rooms used by guests. A copy of the section posted and printed in distinct type in not fewer than 10 conspicuous places throughout the hotel or inn. Exception: notwithstanding compliance with subsection A, a hotel is liable for property loss or damage if a guest delivers property for custody in the safe or vault and the hotel keeper omits or refuses to accept it, deposit it in the safe or vault, or provide a guest with a receipt, except that a hotel is not 1. Obligated to receive from any one guest property exceeding a total value of $300, or 2. Liable for the amount in excess of $300, whether or not the property was actually received.
That's a lot of information to get in 30 seconds.
In modern times, many jurisdictions have modified this rule so that the hotel's liability is limited. However, the hotel must abide by certain regulations. The laws regarding hotel liability vary by state, but most have some things in common.